Morning, everybody. Happy Tuesday. Let's start this thing. Welcome to the In-Rem Podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Good morning, everybody. I'm Andy Fowler. I'm here with Sean St. Clair. If you're new to the show, give us a like, subscribe to our channel. Also, we value your feedback. Leave us a comment below. We'd love to hear what you have to say. With that, Sean, we're going to go to you. Give us a legal update.
Thank you, Andy. So my legal update for today, or legal discussion, is purchasing properties at trustee sales. And I'm going to discuss kind of the Arizona process here, but I know that there are a number of states that are deed of trust states, and a lot of the general information I'm providing here might be applicable, but that anybody listening outside of Arizona, follow up with a local attorney to, discuss the laws of those particular states. And of course, what I'm providing here is legal information. And, if you want to buy or not sell, you can't really sell property at a trustee sale. That's what a trustee does. But if you want to buy property at a trustee sale, talk to an attorney and get specific legal advice. But in Arizona, there is a investment strategy for purchasing property at trustee sales. Obviously, the way the market has been the last, 5-6 years, not a lot of foreclosures are taking place. However, who knows what the market has to bear in the next few years, and we may start seeing some trustee sales. And so there are opportunities to, purchase property for less than fair market value at trustee sale. There's really two types of loans that go to trustee sales. So the first is, and I'm talking primarily residential property, although you can buy commercial property at trustee sale, and what I'm discussing would be applicable to that. But there's two types of loans. There's your first position loan, and then there's your second position loan. So if you go to a trustee sale and you purchase a property through a foreclosure of a first position loan, that will result in your ownership of the property outright, not subject to any other liens. Examples would be a second position loan or deed of trust, and that will be wiped out as a result of the trustee sale. Another example would be your HOA liens. HOA liens are never superior to first position deeds of trust, and so those would be wiped out as a result of the trustee sale as well. The only thing that would remain would be property tax liens. Those are super priority liens and will need to be redeemed or satisfied upon the purchase of the property at the trustee sale. But, on residential property, tax liens are not a significant amount generally, and for a few $1,000s can generally be satisfied. Now, if you want to find out or determine or make sure that you're purchasing a property via a first position deed of trust, and make sure there's no other title issues out there, such as, prior easements, prior in time easements, or things like that. And that's something you need to be careful of. Just because you're buying a first position deed of trust and you're wiping out anything after that deed of trust, including HOA liens, you aren't wiping out, say, prior easements, prior title issues, things that came prior in time to that loan. The way to, do that is to obtain a conditional title report on your own from a title company. Now, this is not insurance. Condition of title report will tell you what's out there, what's affecting the property, but the title company providing it is not ensuring that the information is accurate. They're just giving you, a basic abstract of the title. The other way to find out is, a lot of times the trustee who's selling the property will in fact offer and provide for a fee of, say $30 to $40. They will provide a copy of their trustee sale guarantee. So when a trustee is going to foreclose on the property, they obtain their own title insurance to make sure that they're providing the proper notice to everybody and to find out, whether or not they're going to be able to convey clean and clear title to the purchaser. So they go and obtain their own title insurance. And a lot of times they make that available to potential purchasers. And so you can contact the trustee and see if that's something that is available. And then that'll be a title report. Once again, it's an abstract of title. There's no title insurance. It's not a guarantee of title. So if there's something that's not on that, trustee sale guarantee that later you find out about, well, then, you're not covered by insurance and you're going to have to deal with it, but it at least gives you an idea. And that, a professional title company or title examiner has looked at the property and this is what they, found on their investigation. Another type of trustee sale occurs on second position loans or deeds of trust. And so those are loans that are going to be inferior to your first position loan. They'll be inferior to your HOA lien. So if, money is owed to the HOA for assessments, then those will have to be satisfied upon the purchase of the property. However, there is a strategy that can be employed that, makes sense to purchase a second position loan. A lot of times you're getting those at a hefty discount. If the loan's $100,000, you might be able to purchase the property for $10,000 or $20,000 or whatever number makes sense financially. So you're not paying the full $100,000 loan. You're paying, 10 or 20. However, the first position lien remains. Well, that's not a bad thing because you as a successor in interest or new owner of the property, a record title holder of the property, because you do get record title as a result of that trustee sale, you become the record title holder. You have a right to make payments on that first position loan. You have a right to, if that first position loan is behind, our statutes clearly state that you have a right to find out what the reinstatement amounts are and to bring that loan current as a successor in interest and title to the property. The only time that wouldn't apply or you're not going to be able to do that is if the first position lender accelerates, and they may accelerate on the basis of what we call a due on sale clause of the property where, the original borrower or owner no longer owns it. That then gives the lender the right, but not the obligation, not the duty, not the requirement, to invoke the due on sale clause and say, hey, I'm accelerating the full balance and I need to be paid off. In that case, that will have to be dealt with if you buy a second position loan. If there's equity in the property, then you can sell the property. But the lender has a right to accelerate and refuse, partial payments and to go to a lawsuit, a judicial foreclosure via a lawsuit by that method. A lot of people think, oh, well, if the property sold, the lender, the due on sale clause automatically kicks in and there's a breach of the loan documents. And that's not the case. It just simply creates a contractual right for the lender to accelerate. But ultimately, if you are there and you own the property as a second via the purchase of the second position loan, you can make monthly payments. And the interest on that first position loan is probably a lot less than what you would receive from a hard money lender in order to, make debt payments or interest only payments to a hard money lender while you fix up the property, improve it, and sell it. But that's something to be aware of. If you purchase it at a second via a second position loan, is the ability to make those monthly payments to the lender. So basically, for out of pocket amounts of much smaller than what you would have to be out of pocket to buy a first position loan, you can then own the property, satisfy the first position lender, fix the property up, improve it, and then turn around and hopefully sell it for a profit if you're looking to do like a fix and flip or something like that. Or you can hold it and satisfy the first position loan. And then if the first position lender does choose to accelerate, well, you own the property at that point. And if there's equity, you can sell it, pay off the first, and take your equity out. So there are deals to be had through purchasing at trustee sales. So if the market does shift, keep in mind that that is a strategy that can be employed to find properties at a discount.
Sean, to what extent should real estate investors, like you've mentioned before, we've been in a good market. So this is less of an issue maybe now, but those of us who are around during the last bad market, some of the best deals to have from an investor's perspective are those deals where maybe things went the most wrong, whether it was in development or construction or whatever else. And back then, I remember some of the issues that investors would run into, or where they thought maybe they did their due diligence, were dealing with properties that were in the middle of construction, which kind of is an indicator to an attorney, but maybe not as an investor, is, well, maybe you should be watching out for what we might call hidden liens, like mechanics liens or things like that, where work stopped. They might not be a matter of public record. Is that something that should be, especially if the market flips and where the investment opportunities are different, is that something investors should be watching out for?
Yeah, that's a great question. So I didn't mention mechanics liens because I was presuming that the property being purchased is, a residential home already existing. But to the extent that somebody's thinking about, hey, I'm going to go and purchase a property at a trustee sale that's, land that's, had any type of improvement done on it, and you can tell that, whether it's, clearing or, some foundation work has been done, some framing work has been done, but, the developer ran out of money and they've lost the property in foreclosure. Keep in mind that mechanics liens are unique because basically they can jump back in time to when work first started in the development. So if it's all, one construction project, then you could have somebody who did work on the property after the construction loan was obtained, after the loan was, or the deed of trust was recorded, yet the priority of their lien may jump prior in time to that deed of trust, because maybe the initial, grading and clearing of the property work started, 5 months before the loan was obtained. Because a lot of times, these developers, they buy the property, they buy it in cash, the vacant land, and then they start, hiring the contractors to come out and preparing the land for construction. Well, if it's all one project, then anything after that could, revert in time or jump back in time and take priority over the deed of trust. So that's something to consider if you're dealing with partially completed developments. There's going to need to be some due diligence there to see if any mechanics liens have been recorded, or if they haven't been recorded, trying to figure out who's done work out there, if they're owed money, if they could, have priority over that loan that you're purchasing.
All right. Thank you so much. So let's get into the substance of today's show. Today's show is titled Investor's Guide to Probate Leads. And with us today, we have Rilus Dana. Rilus is an estate planning and probate attorney with Dana and Associates. He's a real estate investor and the owner of MAAT Legal. Rilus, thanks so much for being with us.
Thanks for having me. You guys are so official. I had to get my lawyer to look at that waiver you sent me.
Yeah, we don't do anything halfway here. That is the product of our legal education. Unfortunately or fortunately, one way or the other. But we're so happy you could be here with us, Rilus. Tell our audience, what states are you licensed to practice law in?
So I practice in Arizona and California. I'm licensed there. I took the Nevada bar, but I've been just inactive there. I don't really practice there.
So what percentage of your work would you say is broken up between Arizona and California?
I'm mostly Arizona, probably 90% Arizona, I would say, only about 10% or so California. Seems like I get most of my California clients from my Arizona network. people that are in Arizona, but they have properties in California, or kids or parents or things like that.
Tell us about MAAT Legal.
Yeah, so Mont Legal. So what that is, so I've had partners. My dad was an estate planning attorney. I went to college. I studied business management. I always knew I wanted to get in the business of law because I feel like, as a business, lawyers are kind of behind the times. So Mont Legal is kind of the culmination of how to create the perfect estate planning law firm. And what it's merged into is a practice management company. So some of the tools that I've developed, like the software that I use to draft my estate planning documents, I spent a lot of money in the process. So now basically I'm sharing that with other attorneys. So instead of hiring associate attorneys, I'm growing through Mott Legal, basically sharing my resources, but I'm encouraging attorneys to have their own brand, their own thing. So that way they're more motivated to build their firm. And Mott Legal is just the tools to support them.
Hi, Rilus. Good to see you. Thanks for joining us today.
Yeah, thanks for having me.
So, Mont Legal, I mean, this is, to me, something that's so needed in our community. It's one of those things where we go to law school, we learn the law, we learn how to practice, and yet we come out of law school with no clue where to even begin. So as far as what you're doing there with Mott Legal, how long do you have to practice to be or participate in Mott Legal? Are you taking people from, hey, I'm right out of law school, I'm ready to hang my shingle, and I'm gonna, start doing estate plan work? And do you take those, or are you looking for more experienced attorneys that maybe are working at a firm and have that legal background and want to maybe jump ship, or maybe even have been in practice a while and their business is stale or stagnant? Who are you looking for? For Mott Legal, who are your prime clients?
Really, either one of those. So, but I would say I appeal more to kind of the fresh out of the box people. They haven't already kind of made up their mind of how they think their law firm, should look like, and what it should be like. So I can take someone straight out of the box. Right now I'm just in Arizona and California, the states that I practice in. So I've been using it myself for, I guess over 4 years now. So I've had the whole separate entity, where so I had to create it first to see if it works. So it's like, all right, how would this work? So I've been, kind of wearing both hats. So in my law firm, Dana and Associates, it's really just me now. I'm the only attorney, and I have paralegals, receptionists, and everyone, all the employees are through Mott Legal. So if there's either someone brand new that's like, hey, I'm ready to build my own estate planning business, is a good fit, or someone existing, like a firm like yourself, you guys are doing some estate planning. I believe, I don't know if you have a paralegal doing drafting, but right now the Mott Legal system, the way I'm offering it, to use the software and all my systems, it also comes with a virtual paralegal. So you got to run your practice the same way that I do as Dana and Associate. So after I'm done meeting with the client, I task my paralegal, and she'll manage the client, and she'll draft the documents, and then I do the document review together with the clients. So all the work I'm doing for estate planning in the Mott Legal system is with the clients. So I feel like this is the best use of the attorney's time. There's no time spent drafting or doing any of the tedious work.
Well, that's a great setup and structure, especially for, newer attorneys. I know when Andy and I first started, we had no staff because we couldn't afford them. It's like, we're just starting. I started up and I had a card table in my office because, I didn't have a desk. And so I had to shop around and find a discounted desk, a cheap desk, because, we were starting up from scratch. But I was doing all my own scanning, and I was doing some estate plan work and doing all of my own drafting and things like that. But to have been able to have an experienced paralegal that I can pay, either through a monthly subscription or through, a project-based type payment, that would have, been a big help and have gone a long way for us when we were first starting up, for sure.
Yeah, so that's what we bring with Mott Legal. So instead of doing that all yourself, trying to get someone, what's also cool about our new world, where it's easier to outsource, is it doesn't matter where the talent's at, right? So that kind of opens up your paralegal search really to the whole world. So because it doesn't matter, right? If they're working remotely, you don't really care where they're at. So you can get someone really specialized. So for Mott Legal, she's located in Idaho, our paralegal, and she actually works in a firm there by day, and she does all of ours by night or by in between, because the software actually drafts a lot of it, but I still like a human to run it, right? Because people usually have questions or they change their mind later or things like that. So her job is really just kind of manage the client and push them through to the next step.
Very cool. Now you're also doing some real estate investing yourself. Is that correct?
Yeah. So I've kind of gotten into it backwards, doing probates. I've always been a fan of the cash sales, especially when there's, hoarder houses or cat houses or, all the stuff that's maybe not ready to go right on the market or any other problems. I like working with real estate investors to solve those problems. So that's what's kind of opened my eyes to that world.
Yeah. So Rilus, our topic today is Investor's Guide to Probate Leads. So how do you and how does your firm, how have you traditionally worked with investors on probate transactions?
So how have we done it? So if they bring me transactions, so I like networking with the investor community, especially in Arizona. And I just say, hey, like if there's ever a dead person on title, I'm your guy. Let's, if there's, a problem where they can't sell or some sort of title issue, that's when I can help you out. So I try to structure it where I can help them, close their deal and then also do the legal work on there. So what we've come up with or what I've seen work well, a lot of times the family, maybe they're just interested or, there's problems or they don't have the money to pay to hire a lawyer to fix the property or whatever it may be. So even just hiring an attorney can be a problem. Now, if a stranger comes to me and says, hey, we want to do a probate or we need a probate, and the house is the only thing in the estate and we're living there and we're going to keep the house, then I don't know about you guys, but I charge all my fees up front. So it's like, great, if you don't have the fees or the ways to pay me now, how are you going to pay me after I do all of the work? So it can be even harder for them to come up with the money. But if they already going to try to sell the house, I know that I'll be able to get paid once the house sells. So if they're working with one of my trusted advisors, someone that comes to me through my network, the way we typically structure the deal is we have the earnest money on the contract be used for the legal fees, for a deposit on legal fees. So that way we can pay the cost, especially like the filing fees of the probate and publishing fees, all of those fees. And then we get paid the rest of the probate fees after the property sells.
So that kind of leads into my next question, but it sounds like you're able to or have tailored unique fee arrangements or fee agreements with clients to accommodate trying to get the property sold.
Yeah. Yep. So just trying to solve the problem, right? I really like the real estate investor mentality, and I feel like we're a lot the same as an attorneys. We just have different tools. So, if they're trying to help this family, sell this property, we need to make it as easy as possible. So,
I don't know if this is your experience, but ours has been this way, which is real estate and probate just seem to go hand in hand, because the one thing that everybody does have, or the one asset that it seems everybody has, is real estate, right? And when they pass, though they may not have died with 10 or $100 million or maybe 10,000, but usually they have a home. And if they haven't planned appropriately through a will, trust, or whatever the case may be, which many people haven't, That leaves, an immediate title issue that has to be resolved through a probate with a probate attorney. Do you see a lot of cases like that?
Yeah, you're right. A lot of times that's the only asset, and it sneaks up on people, I would say. Meaning they don't think they have anything, they don't think they need to do any planning, but yeah, they've owned a house for 20 or 30 years, and um, that's generally enough equity. In Arizona, the magic number is 100,000. If there's more than 100,000, then we have to go through probate to collect it.
Yeah. So, Rilus, give us an idea uh, what the common investor or person who has to face probate, the common types of probate that they might be facing here in Arizona or California, the areas of your practice. What would they typically be looking at?
Yeah. So the first thing I would say to the investors, I've talked about this before on other shows and other things, is to do some homework. I don't know about you guys, your firm, you probably get these calls too. Like people get all excited, like, hey, like we need an attorney, like, and you start talking to them and you realize they don't know what's going on yet, right? Meaning you got to know, who's the person you're talking to? Is it a granddaughter? Is it anyone that has authority? Who's on title? We need to know things like that. And then if someone's dead, if there's someone dead on the title, we need to know if there's a will. If there's no will, then we need to know the family members to figure out the intestate heirs. So I'd say do a little. Don't be lazy, right? If this is your deal you're working, have that type of information figured out before you call the lawyer. And then in Arizona, we can do what's called it's usually an informal probate. Informal means you don't have to put on a tie, go to court. You don't actually have to have a hearing. Generally, if everyone's in agreement, you can file everything with the court and they'll approve it. Now, if people are not in agreement, let's say there's no will and the kids are not in agreement of who's going to be in charge of the estate, then we would have what's called a formal probate, where you schedule a hearing and just good old litigation, right? If they agree, you get someone appointed, but if not, it could go on forever just fighting over that issue.
So clients come to the door, investor calls up, they say, man, we want this property, we want to move on it. Grandma owned the property, she's just passed. At what point can they expect, assuming all of these probate issues are able to be ironed out, at what point in that process could they expect to close escrow?
In Arizona, what I say is about 4 to 6 weeks. So that timeline, that gives my team 2 to 3 weeks to prepare the initial paperwork. And then once we file it with Maricopa County, we're seeing them take another 2 to 3 weeks to process it. So that's how long that's how long it takes to get the authority. There's still going to be a bunch more work to do after that, but the main thing is that's when they can close the deal.
How often do you get those deals where they've already listed the property or purported to list the property because they likely don't have the authority until a probate's done to even enter into a listing contract with a real estate agent, but where they've already listed it and escrow's been open and they got to get the deal done? Do you see a lot of those?
Yeah. I'm sure you guys do as well, right? So sometimes they don't. I don't know if they don't know or if they're not looking at that, right? Like, who's going to sign your contract? That should be the first thing you're looking at. Like who has the legal authority to sign your contract? So, but sometimes there may be like a weird title issue they didn't see. I'm doing one right now. They sold the properties. There's some multifamily. Someone sent them a flyer. I always ask, like what made you sell? Someone sent them a flyer, and the title company didn't like one of the old deeds they did themselves. I think someone passed away. I think mom or dad passed away. His parents, and then they transferred the deed from there into a trust. So it wouldn't have been obvious, to the agent, or if they were, looking. It looked like they had title, but when the title company did their report, they found there was an issue. So yeah, it's real common for title companies to find a dead person on title somewhere.
Rilus, have you ever come across a situation where the deceased was a hoarder and the
Oh yeah.
house. How do you go about working with your client to resolve that?
I recommend they don't deal with it. Just sell it
Okay.
as is. Let someone else handle it. Like our friend Pace. Pace is an expert at those. Um, I was cruising around with Pace one day, back in the day when would take everyone in his Prius. I guess he still does. But he was like, "Hey, you want to go buy a hoarder house?" And I was like, "Sure, let's check it out." But super common for them, and I guess they had it cleared out within 1 or 2 days. So my advice is get with the professional. Families could mess around with that for weeks and weeks. And then I hate when the families do it, because they want to bill their time. And it's like, great, I know you're a fancy bigwig, whatever you do, but the estate or the trust can only charge what we could pay somebody to do this for, right? And this isn't highly skilled labor. You're talking about, throwing trash away. So I would say don't. Hoarder houses, let a pro deal with it.
What's the worst house that you've ever come across?
Again, like I guess like the people that I send him to, I've sent Pace to some scary places, I guess, where he went and checked out some things. I don't go. That's the beauty of it. I don't go firsthand, but I've heard about some nasty things.
Well, that seems to be why it's kind of a good marriage of between the investor and the family trying to work their way through probate, right? Because the family in probate, they just want to move this asset. They just want to liquidate the asset. Most of them, in our experience anyway, are dealing what they have to deal with is kind of mind blowing, and they just want to be past it.
Yeah,
And the
then you have
investors,
the emotion of the loss too, right? Like it's a hard enough business transaction, and then you throw in those extra emotions.
right? And on the flip side, you've got the investor who's willing to do the work typically to get a good deal, and it just seems kind of like an obvious marriage between the two, where one can help the other, or each other help both.
Yeah, and that's where I feel like there's a big opportunity for attorneys, and you guys know this, right? You guys have tapped into the real estate investor network, but I've had lots of legal fees to my firm that I wouldn't have gotten because unless I had a real estate network, meaning they called me, but first they had a problem with the real estate, so I connect them with someone else. And because of that, they end up hiring me later for the probate.
So
Whereas they would have just moved on if I just tried to pitch my legal fees right then.
right. So if an investor, whether they're new to the game or they've been around for a while, for the investor that wants to kind of tap this resource or develop probate leads, where do you suggest they start?
There's lots out there on how to target these clients, right? These people. I know I even get bombarded just being the attorney on record. I get, text every day and, all that stuff. I think the best opportunity is with the probate attorneys, the attorneys that are doing the probate. I say number one, bring them a client is the best way to get to know them. You'll find someone needs a probate, and that's a good way to get to know an attorney, and where you're not trying to pitch your services at that moment. You're just hiring the attorney for exactly the work that they do. And then that's an opportunity to show them how easy you can make the transaction for them, right? If you're doing the legwork, if you're taking documents for the client to get them to sign, and all the back and forth, meeting at the hoarder house and helping them find solutions to all of that, then that's going to show the attorney that's someone they want to work with. And then they're also, I feel like you get to know their paralegal as well. The attorneys get too much attention. The paralegal's not enough attention. And a lot of times the paralegals are the one dealing with the problems. So they like to have solutions. So if the family's calling them about personal property or whatever it is, it's not, they're the ones that, if there's no solution, a lot of times it falls onto them, right? They got to figure it out, or they got to deal with the upset clients until it gets figured out.
So if I'm an investor and I want to basically get to know some probate attorneys and maybe start, providing some clients to them and see if I can develop some goodwill, Where do I start? Do I just cold call? Do I show up are there events that, you're going to find probate attorneys at? Where would I start to meet a Rilus Dana and start, sending some clients his way and creating some goodwill?
Yeah, that's a good question. There's not many attorney groups, are there, Andy and Sean? It's like I'm happy to hang out with you guys here today and talk legal, but I feel like there needs to be more attorney groups. And I was talking to Jamil on the Wholesale Hotline, their show. The audience probably knows Jamil and Pace and those people. And I told him I'm trying to be in the attorneys, and Jamil just laughed. He's like, "Yeah, good luck," because it's attorneys. I don't know. We're a weird bunch, aren't we? We don't really like people all that often. It seems like we don't like groups, and there's just so much liability, I think, associated with attorneys. Right? They're kind of nervous to do anything.
Well, yeah, I mean, these real estate investors who are, there's some collaboration, but a lot of times they're direct competitors. They have all these meetups, 2-3 times a week that you can attend and, talk to other investors, and they share strategies and different things. But us attorneys who, there's a little bit of competition, but it's not really, direct competition because of our ethical limitations, don't really, allow for direct solicitation and those types of things. And so you would think that we would have more of this, collaboration in these groups, but, especially since COVID, nothing's really come back. Maybe before COVID, there was once a month you could go and attend, some real estate law section or probate law section, meeting or something like that. But at this point, a lot of it is still online, and there's just not much out there. I'm guessing you see the same thing, huh?
Yeah, and I don't know about you guys, but I'm sick of like the same people speaking at the same things, right? It's the same stupid sponsors, the same stupid people, the same people that sit up front, make the wisecracks, right? And it's kind of like the cool kids club. And I don't know, it's hard with the attorneys. So I guess kind of getting back onto our topic, that's why I say the best way is bring them a client, right?
Yeah.
If you want to tell an attorney how great you are, they don't care. How often you guys hear it? We get stuff in the mail, probably at least I would say 2 or 3 times a week. Something from investors and real estate people, and it's just a numbers game, right? If it's the right timing, maybe those pieces work for someone. If the attorney, needs that solution right then, and actually, trust you enough from your piece to reach out to you. I would say number 1, bring them a client. Number 2, if you don't have a client, I would say stop in their office with some baked goods, some sugar. Right? Would you guys turn that away? Someone came to your office and
I've not had an investor do that, but I had like a marketing guru out of the blue send a huge edible arrangements basket. And so I pulled the business card off. I'm like, well, they have my attention. And if they can get my attention, out of the blue, unlike a lot of people who try to cold call me and whatever, I just kind of, brush them off. But all of a sudden I'm like, well, this is pretty cool that they've, were willing to do this. I'm like, and they're a marketing guru, maybe they're worth it. And I picked up the phone and called them and said, hey, let's schedule something, so they at least, got me on the line where normally they wouldn't, by doing something along those lines. So that's not a bad suggestion at all. We like to see that kind of stuff.
You're way more likely to get attention. I would say your plan should be or your goal should be just that, just to get their attention. Don't try to meet them that day. Don't try to talk to them. Because again, you want to be helpful. You don't want to be annoying. You don't want their team to be like, oh, like I got to help this guy, or what does he need? Does he want me to go back and get my boss and he's going to yell at me? Like, why'd you interrupt me? So, just make it really easy, leave something nice and make a good impression. And I think that's way more likely to develop a relationship that way.
Well, and Rilus, this is where I think attorneys are not really all that different than real estate investors or any other investors, in the sense that we respond to things that bring us value, or in what way can you bring us value? Now, obviously, if you bring us a client, that brings us value. But as a probate attorney, for instance, and you mentioned it before, lawyers, like all of us, but especially us, and even if your name is on the firm, like your name is on the firm, you're probably getting inundated in your email from marketing firms all over the place telling you all these leads that they can bring you and everything else. But you never respond to those because you know it's going to cost you a pretty penny, and they're really just looking for you to pay for this. Versus, you don't have to bring me a client as a probate attorney. If you can come and say, hey, look, I'm a real estate investor. I'm looking to invest in properties. I know you represent clients that need to move properties. I just want you to know that I'm out here, that I'm a resource, because the old way of doing it, when they needed to move a property in a probate was, well, let's just go get a real estate agent and list the thing. But that might, that's going to come with commissions. Maybe that's a great deal. I don't know. But if I can make a connection, the moment my client asks, or even before they ask, hey, you're going to need to move this property, let me connect you with ways that you can quickly do that. That provides immediate value. And I think a lawyer is going to respond to that. Do you agree?
Yeah. I said, step one, you got to get their attention. And then that's a good thing that you can help with, right? Where, like provide value of a property specifically, right? A way to provide value is to help value or give some sort of idea of what the property is worth. So I usually recommend my clients, in probates and trusts, start with the cash buyer, especially if it needs work. I'm like, there's no better way to tell value, right, than what someone's willing to pay right now for cash, willing and able buyer. So, and if that's in the ballpark for people, that's a great solution a lot of times. If there's 5 kids and they don't want to wait, and they just want it sold right now. Now, even if that price is too low, it still provides value to know, hey, all right, that's what the cash price is. So if we list it, then maybe there's a chance we can sell for higher.
In trying to cultivate leads with probate attorneys as investors and trying to kind of build that network, how important is it, do you think, the investor look to try to at least network or work with attorneys that have dual experience in not just probate, but in real estate?
I'd say not important. There's a lot of probate attorneys are just kind of probate. I mean, real estate's a big part of probate, as we discussed. But I consider you guys real estate guys as well, where you actually do like the, Sean was teaching us about buying liens and things like that, and you guys do more of the real estate, litigation and like that. But I think you can go just regular probate attorneys, that are good at, doing probates. And as part of that, if they're a good probate attorney, they're going to be pretty good with real estate. I think goes kind of hand in hand.
Yeah. Probate's one of those areas, which is unique. And I have a lot of respect for probate attorneys. Like you said, our firm does a little, I don't do tons of probate work myself. We have an attorney that Dustin Shanaker, who does, all of our probate work. But what I admire about probate attorneys is you have to be a jack of all trades if you're a probate attorney, right? Because you don't know what asset is going to be in the estate. It could be, real property. It could be residential. It could be commercial. It could be, you could be dealing with creditors, and so you have creditors' rights and, claims that are being made there, and you have to be able to negotiate, short payoffs or, figure out if the debt is valid. You could have a business ownership, so how do you distribute or convey, stock shares? How do you deal with membership interests in an LLC? But we could go down the list, but there's all these other areas of law that are, related, or you have to be aware of to basically process and properly process an estate. Have you found that, in your practice?
Yeah, I would say that's what keeps it fun. And then I rely on experts, right? I stay in my lane. I know, I say a lot of times I know enough to make me dangerous, right? It's like, hey, here's what I learned in law school, but we need to get someone that is actually practicing in this area and knows how it is today. So, but yeah, I've ran into a lot of those different things, businesses, commercial, and for better, for worse, it's all over the nation. So it's hard where a lot of times it's like a one-off thing. It's like I need someone in North Carolina for a partition action, or I need someone in wherever to help with a commercial business. So yeah, that's part of probate, but we rely on experts, I would say, to when it gets down to the niches.
Right. So the probate attorney is kind of like your, family practitioner, your medical doctor you go see as your primary care physician. And then they identify the issue and say, oh, I don't like what that looks like. Go see this specialist. And so, you as the probate attorney are kind of filling that role, and you're spotting those issues and then saying, well, we need to figure out how to unload this membership interest in this LLC. Go see so-and-so. They do, business related work, and they can work with us on that.
Yeah, that's a good analogy. I always say, like, big picture, we're just trying to collect everything, whatever is out there in the estate, we're just trying to collect it and then distribute it to the next level. And that's where I've dealt with your firm, some of the other attorneys on some of these real estate issues when there's, people sue over contracts and fun stuff like that. That's when I call your firm or someone else to solve those things.
So I know that I've seen investors, or I've seen lists, probate lists that people can obtain, which show basically the probate filings, for example, here in Maricopa County. I'm sure they're available, for other counties in Arizona, as well as, outside of Arizona. But they have probate lists, and they basically show the name of the decedent and the case number and the name of the personal representative and whether or not there's an attorney involved, that type of thing. Have you seen those lists? And if so, do you know where investors can obtain those lists?
I think there's several places they can get them. They can, it's going to vary in everyone's county, but one obvious place is maybe you can go to the court itself, maybe in person or maybe online, to see if they publish that. And then there's data places, like PropStream, and a lot of places sell that data.
Go ahead. And I'm sorry, I didn't mean to cut you off.
No, go ahead.
If you have, let's say you have that list, how would you mine that list? Meaning, who would be, if you were an investor and trying to figure out, okay, this probate was open, this personal representative was appointed. Do I want to contact them or don't I want to contact them, for example? What would you do, or what would you be looking for to figuring out who I want to contact to see if they have property and if it's something that I can, help them with or purchase, that type of thing?
Yeah, it kind of hurts me to say this, but I would say that the personal representative. I tell my legal clients, so I say, don't answer your phone. I'm like, you're going to get inundated.
Right.
Don't answer your phone. But that's why I'm kind of like, ooh, it kind of hurts to the other side. But on the other side, though, is the personal representative. A lot of times they have someone like me, or maybe they don't. Maybe they're doing it themselves, or maybe the attorney is not very hands-on. But a lot of times the responsibility is in that person to sell it and to figure out what it is. But I know I've tried to introduce people to my network, and they're already in love with some realtor or someone they talked to because they knocked on their door, they called at the right time, or they've already established a trusted relationship. So I would say that it does work, although just be respectful. Like, someone just died, and be careful if you're calling like the next day. Some people are really going to get, I wouldn't say that that someone died. Although you're calling on a probate list, don't be like, hey, I heard someone died. It's
right.
just, just kind of a general, you buy houses, you're interested in their house. Don't mention the fact that there's a probate going on.
What are some ways that you can figure out if there's even real estate involved in the equation, right? So somebody could be appointed as personal representative and the decedent didn't own anything, or they just, owned assets that need to be probated that aren't real property assets. How would you go about finding out if the decedent owned real property, so that you're not just calling randomly and you at least know that, hey, this is somebody that, may be a warm or a potential lead.
One way is you can buy that data. The other way is kind of do some homework, right? Get on Google. Like in Arizona, it's really easy to see, how it's titled. So you can look at things like that. You can also buy a pre-probate list. So I've been buying this one lately and sending just mailers to it from my law firm. But the idea, or supposedly, someone died and they own real estate. They may or may not need a probate because they might have a trust, or it might be in two owners' name and only one passed away. But I feel like that's a good list because, for me, that's usually a good time to do estate planning. But that's also times, it's high likelihood they could need a sell.
Right. So in at least here in Maricopa County and some of the counties outside of Maricopa here in Arizona, a lot of information is available just for free on the assessor's website, right? So if you have the name of the decedent, in theory, you should be able to plug their name into the assessor's website, and assuming that spelling is right on your end and on the assessor's end, it should pop up whether they own that real estate. Have you seen that employed as a strategy?
Yep. So that's a lot of times I would say, I think people find the property and then kind of go backwards that way. They find the properties in the name of a deceased. They see that probate's open, then they contact that personal representative. Or the lawyer may not hurt either, too. Again, they may throw you right to a voicemail. They may flush you, but just, I don't think it hurts to let them know that you're interested in making an offer on that property. Because the lawyer may be bugging his client, say, hey, what's going on? Have you sold this? Or, we want to close the probate, but we're waiting for the personal representative.
So we've been talking about personal representatives and, formal and informal probates. Talk to us a little bit about affidavits of succession and how investors might be able to, identify those and potentially, pursue those leads as an option.
Yeah, so I call it like a probate substitute or mini probate. So in the checklist for investors, make sure you're talking to the right person that's going to sign your contract. And then if you find out someone is dead on title, look at the value of the property. So depending on the value, and the way it works in Arizona, you take the tax assessed value in the year that you're going to file the affidavit. So we're in 2022. If we're going to file it this year, doesn't matter they died 5 years ago or 10 years ago. We look at the assessed value of this year. If there's a mortgage, you get to subtract that. So it is the net amount. So if it's $175,000 assessed value, but there's a mortgage of $80,000, they made it barely, just by $5,000. And I don't know about you guys, I've done a lot of probates for just that exact amount, just barely over, or personal property for like $76,000 when 75 is the magic number. It happens a lot that way. But yeah, look at the value and see if there is some sort of substitute available. Now in Arizona, the way it works is you have to wait 6 months after the date of death. So if they just passed away and it's below the value, the time could still be a problem. If there's going to be a foreclosure scheduled for sooner than that, you don't have the time to wait. So with probate, we can usually get someone appointed about 6 weeks or so, even though the whole process takes longer and is ultimately more expensive, but it's a faster way to get authority. Yeah. The other thing to say about, or go ahead. Or last comment about affidavits. Yeah. I describe it as the in-between. It's kind of weird because no one's ever formally appointed by the court. So if this house is the only asset and it's below the value, it'll work for that. But if you think there's a bank account or some other investment, these companies aren't going to talk to you because you're not formally appointed by the court.
Right. So that whether you pursue an affidavit of succession could be dependent upon whether or not there's other probatable assets out there that you're going to need to access. And if there are, might as well just do the probate because you're going to be doing it anyway. And I could be wrong, but I don't think you can do an affidavit and a probate.
Correct. Yeah. So that's part of the thing. Doing the affidavit, you're swearing that you're not going to do a probate.
Mm-hmm.
So.
The other thing that I've discovered is one reason you may not want to do an affidavit of succession is because you're putting the heirs on title. And then they could be, if you have a hoarder house or a house that has problems, and they become aware of it or should have known about it, and then they go and they sell it from their name. Now they're responsible or liable for those problems, versus if it's sold by the personal representative, well, then, it's an estate problem. It's not the individual beneficiary's problem at that point.
Yeah. And if there's 5 kids, they're all going to have to sign that affidavit. They're all going to have to agree on the sell price. They're all going to, versus if you do a probate, even though there's 5 kids, you can have them agree to appoint just one to sign everything, just one to sell the house. So yeah, good point.
Rilus,
go ahead.
No, I was just gonna go ahead and finish your thought.
I just say, although it's possible, it's not always the best thing. I'm always looking for the easiest way. So if it's there, but it's got to be, there's only that one asset that you're confident, limited beneficiaries, and they're all willing to sign, willing and able, and you can wait the 6 months. Then yeah, that's the easiest way of those ways.
Well, Rilus, this has been great information. Where can real estate investors find you?
Yeah, you can go to rilusdana.com, my first and last name. It's got links to my websites, YouTube channels. I try to do lives regularly in Mott Legal, and then attorneys should join my private Mott Legal group. So I'm going live there every Tuesday at 5:30 is the time. And it's just a space for attorneys to hang out, basically talk about, practicing law and how we can help each other out and run our businesses.
Awesome. Well, Rilus Dana, thank you so much for being with us. The information's been great, and we look forward to having you again.
Yeah, I'd love to. Thanks for doing this, guys, and everything else you do. I appreciate all the content you put out, and it's been a privilege working with attorneys in your firm. And yeah, thank you.
Thank you.
Thank you, Rilus.
We'll talk to you soon. All right, everybody, that is our show. A reminder, join us next week where we're going to be talking about title of the show, Show Me the Money, Structuring Subject to and Seller Carryback Transactions. Our guest is going to be Texas attorney Scott Horn. Should be a good episode. We'll see you next week.
Have a good day, everyone.